Good day, Crime Talk aficionados. It is Sunday, but we have brought to you in one convenient location all of the top stories in one location. That's right, the weekly recap, all the top stories for the week of June 9th, 2025, right here. Enjoy. Thanks for watching. We'll see you next time. And remember, the Constitution matters.
All right, lawyer.
Next. Police continue to search for the suspect in the Washington State triple homicide. That's right. The sheriff's office up there is actively searching for Travis Decker, a 32-year-old former Army veteran wanted for the murders of his three daughters, Peyton, who's 9, Evelyn, 8, and Olivia, who is only 5. Now, the investigation began back on May 30th when the girls did not return home following a scheduled visit with Decker. Then on June 2nd of this year, their bodies were found at a campsite in Leavenworth, Washington, approximately 20 miles from their residence. Autopsy revealed the victims had all been bound with zip ties and suffocated with plastic bags. Decker now faces 3 counts each of first-degree murder and first-degree kidnapping. Police have described him as dangerous, potentially armed, and possessing extensive military training in navigation, survival, and long-distance movement in rugged terrain. The affidavit for arrest warrant notes that Decker's history of outdoor activities, including hiking, camping, hunting, and a 2.5-month period living off-grid in remote areas. For that reason, why they consider him dangerous. Then on June 7th, the sheriff's office released updated images of Decker depicting him wearing a tan shirt with the number 59 on the sleeve, dark shorts, flip-flops, and carrying a pizza box with his hair tied back. The image also highlights very distinct tattoo on the arms and ankles, and a wanted poster advises the public not to approach Mr. Decker and to contact 911 immediately if they see him. Investigators have uncovered evidence suggesting Decker may have been attempting to flee to Canada, and search warrants for his Google account revealed queries back in May of this year, May 26 to be exact, including how does a person move to Canada, how to relocate to Canada, and jobs in Canada, as well as a visit to the website Find a Job. Canada.ca. Now, the campsite where the victims were found is approximately 11 miles from the Pacific Crest Trail, a route leading to the Canadian border. Now, the sheriff's office has concluded roadblocks and large-scale searches of structures and forested areas, but continues to seek public assistance. Residents are urged to review doorbell and security camera footage for sighting Decker and to report any suspicious findings in any recreational areas, noting the time and location. Tragic case. Who could kill their own kids? Absolutely horrific. Doesn't appear to be a whodunit, but obviously you still got to give him the presumption of innocence until he pleads guilty or is convicted by a jury of his peers. The court issued in the Bryan Kohberger case an order staying the stay in that case. Now, what does that mean? So a stay in a legal proceeding, particularly in the context of an appeal, perhaps, is a court order that temporarily suspends or halts the enforcement or effect of pending further action until the appeal is potentially resolved. So in Idaho, stays during appeals are governed by the Idaho appellate rules, specifically Rule 13, which outlines the authority of courts to issue a stay in various types of cases. Now, a stay may be sought to prevent the enforcement of a lower court's judgment or order, but here's the problem. We just don't know. It can also suspend the proceedings in the lower court while the appeal is pending. So, like I said, did something big just happen? Normally, when there's a stay in the criminal matter, that could mean normally a couple things. There's been an adverse ruling against the prosecution, and they want to take it up on appeal. Because normally, the defense doesn't get to take up an interlocutory appeal in a criminal case. You have to basically go through the proceedings and then do that. But there are extraordinary measures where you can do that and say, Judge, this affects our whole case. We're going to take it up on what we call an interlocutory appeal, or here we call it a Rule 21, to say, Judge, this lower court judge made a mistake. Asking the appellate courts to say this judge made a mistake. So here, in the context of our question here, we have the sealed order, staying order. Of course, everything's sealed in this case, it's better than it used to be, certainly better than the Lori Vallow and Chad Daybell case, but the reality of it is still all sealed. Like I said, normally it halts some action or enforcement, and the order is sealed under specific provisions of Idaho law here. Anyway, an appeal likely pertains to either the stay itself, the underlying order being stayed, or the related procedural matters. Now, the court is, like I said, sealed pursuant to this Idaho Court Rule 32G, and the rule exempts certain judicial records from public disclosures, including records of judicial proceedings or judicial work product exempted from disclosure by statute, court rule, or case law. This suggests the order involves sensitive judicial proceedings, such as those related to maybe grand jury, juvenile cases. Obviously, those aren't really applicable here, but it could result or be a result of maybe some sort of ruling as it relates to the continuance that the defense has sought, or the alternate suspect evidence, which is kind of what I would be leaning towards. But we're supposed to have a hearing for that next week, but maybe the judge made a decision already. The problem is, because everything's done in secret, we just don't know. And also, under this particular rule, under subsection 6 of that particular rule says the case can be sealed, which involves records where public disclosure could jeopardize ongoing investigations or the judicial process. Now, the sealing indicates that the order contains some sort of sensitive information, obviously related to a criminal matter. But like I said, the first thought is, well, maybe there's something related to the grand jury. Well, I don't think so. We've had that pretty much resolved, and that's not really in play here anymore. Could pertain to actions arising from the proceedings, and an appeal may challenge that stay, or even possibly the sealing, but that would be very unlikely. So, without access to the specific content of the sealed order due to its apparently confidential nature, we have to infer that the potential subject matter of the stay based on the legal context and the cited provisions. And so it's plausible scenarios for what the stay may address, particularly in the context of an appeal. Obviously, a stay of a criminal judgment or sentence, that's not really an issue, right? We haven't got there yet. He certainly hasn't pled guilty. He's set for trial. Not staying a grand jury indictment because, well, we know that ship has already sailed. Obviously, he's been indicted. We've had litigation on it. And then that's not really applicable. So then we have the stay of the lower court's order. The stay could suspend the district court or, some other court order, and it could be related to discovery, evidence, or a motion in a criminal case. But most of those have been resolved. There's been no real suppression issues that were not favorable to the prosecution, because they're usually the ones that would take that up and say, Judge, our case can't proceed if this comes in. So we'll just have to wait and see. And then there's always a procedural ruling, such as sealing the order itself, where a party could seal the decision to seal the unsealed records. That wasn't make sense, I guess. And then obviously some administrative or judicial proceedings, because, that might halt ongoing judicial or administrative actions. Like I said, that's very odd. And like I said, I just don't like the way everything is a big secret in Idaho, ladies and gentlemen. It's frustrating to the public, who has just as much right to know what's going on in these criminal proceedings as, well, frankly, the parties. There's nothing that suggests that the public cannot handle whatever is going to go on. And you think that we're not going to find out about it eventually? It just doesn't make much sense to me. Anyway, so if there is an appeal, the appeal likely challenges the stay itself here of some type, of some underlying court decision that prompted the stay. Now, the appeal process in Idaho is governed by the appellate rules. Like in most jurisdictions, they have their own rules. And if the stay was issued by the magistrate, the appeal would typically go to the district court, which is not an issue here. And so therefore, it would go directly to the Idaho Supreme Court. In this particular case, but more likely it's some sort of interlocutory appeal. So really what it boils down to, what are the issues that are pending before the court? Obviously the motion to continue and the alternate suspect information. So the question is, did maybe an order come out saying there's not enough evidence for this alternate suspect? Or did the court say, I think there is sufficient evidence for this alternate suspect? And needless to say, either way, some party in this particular case is saying, let's go to the Supreme Court in Idaho, of course, and decide the issue. Could it delay the potential trial? Possibly, if the Supreme Court takes it up. Normally, when you have a trial court proceeding, and there's an interlocutory appeal. It's basically normally what happens is the defense files a motion to suppress something. The court grants it. The prosecution says, we think you're wrong. It goes up on an interlocutory appeal. The defense can do the same thing, but literally I can tell you usually the Supreme Court takes about 2% of those type of cases because they say, let the case play out and see where things go. So it kind of makes you think that maybe the prosecution lost something, but something's taking place and it's big, and somebody asked for a stay and it was granted, which means somebody wants to do an appeal. Now, what happens? Bottom line is we're going to have to wait and see. Hopefully we have hearings coming up here in the next week or two in the Kohberger matter where we can have a little more clarity as to what is taking place. It should really, most motions hearings do set the stage for the trial. This one clearly will, as it relates to the pretrial issues related to the alternate suspect. So we will see where things go, ladies and gentlemen. We just don't know. I don't like to speculate, but when somebody's requesting an order sealing the stay of the stay, it makes you wonder, something's going up on appeal. Like I said, it is time to try this case. I could not agree more. Anyway, the Latah County prosecutors have formally filed their motion in opposition to the Bryan Kohberger defense team and their motion to continue the trial, which is scheduled there in Ada County for the alleged murder of the 4 University of Idaho students. Now, the state argues that Kohberger's request for an unspecified delay lacks sufficient justification, citing the extensive preparation already undertaken by the defense, the rights of the victim's family to a timely trial, and the unlikelihood that delaying the trial would mitigate challenges posed by intense media coverage. Now, for those who don't know, Bryan Kohberger was arrested back in December of 2022 and indicted in May of 2023 for the November 2022 killings. Now, the case has moved from Latah County to Ada County due to significant pretrial publicity, as well as logistical concerns. And then on October 9th of 2024, the court issued a scheduling order setting deadlines for pretrial motions and expert disclosures, which Kohberger's defense team has met without requesting any extensions along the way. These disclosures include 6 expert reports for the penalty phase, over 2,100 pages for mitigation materials, and 55 potential penalty phase witnesses and 132 exhibits. So, the prosecutor notes that despite complying with these deadlines, Kohberger's defense recently filed a motion to continue the trial, claiming that their mitigation investigation remains incomplete. Now, the state's opposition, which was filed on June 5th by the prosecutors in this particular case, contend that the defense has had ample time to investigate and has had ample resources to prepare, and a further delay is completely unwarranted. Now, they also note that the arguments that the defense raises are insufficient. Adequate defense preparation is what the Kohberger team has argued. And the state asserts that Kohberger's defense team, comprising 3 appointed attorneys, 2 investigators, a mitigation specialist, and support from the 1st District Public Defender's Office, has conducted a thorough investigation. The defense has disclosed extensive materials, including reports from 18 experts. 6 of those are penalty phase experts, with 5 focusing on mental health issues alone. They've produced over 2,500 photos and videos and 3,500 pages of investigative documents. The state argues that the defense claim of needing more time for a social history investigation is nothing more than speculative, as experts have already examined Kohberger's medical, mental health, and family history in detail, and they've diagnosed him with autism, OCD, and ADHD, and the state cites that Idaho Supreme Court precedent, noting that counsel is not required to investigate a defendant's entire life to provide an adequate defense. Now, the state also emphasizes that the Idaho Constitution's Victims' Rights Amendment, which grant victims, including the families of homicide victims, the right to a timely disposition of the case. And with nearly 2.5 years having passed since the Kohberger arrest, the state argues that any further delay would infringe on those rights. And the prosecution contends that Kohberger's motion filed after the discovery deadlines and after the pretrial conference is untimely and lacks specific evidence of prejudice that would justify postponing the trial. Now, Kohberger's motion partly relies on intense media coverage, including the recent Dateline episode that revealed non-public evidence to argue that a delay would allow publicity to dissipate. Now, the state counters that delaying the trial is unlikely to reduce media attention, given the case's high-profile ongoing coverage and such as annual stories marking the anniversaries of the murders. And so the prosecution highlights the court's robust jury selection process designed to identify impartial jurors despite widespread publicity is sufficient to ensure a fair trial. They also cite the Idaho and the United States Supreme Court precedent that states and argues that the ability to seat an impartial jury rather than the volume of media coverage determines the fairness. The state also criticizes the defense motion for failing to specify what additional evidence or investigative steps are needed by them. An ex parte motion filed by the defense, which the state was not permitted to review, purportedly outlines these needs, but the prosecution argues that the public record demonstrates that the defense is ready. The state requests that if the court finds merit in the ex parte filing, it be allowed to respond to any specific issues raised. Now, under Idaho law, trial courts have very broad discretion to grant or deny motions to continue, with appellate courts reviewing such a decision under an abuse of discretion standard, which is very hard to overturn on appeal. Now, a denial violates due process only if it is arbitrary and prejudices the defendant's substantial rights. And the state argues that Kohberger's motion does not meet this threshold, as it relies on speculative claims rather than concrete evidence of prejudice. Now, the prosecution also notes that non-binding ABA guidelines cited by the defense have been rejected by the Idaho courts as a standard for effective counsel, and that the defense's work already aligns with these guidelines. Now, the court's decision on Kohberger's motion will determine whether, obviously, the trial proceeds as scheduled or ultimately is delayed yet again. This is going to potentially affect the victims' families, the Ada County judicial system, and the public perception of the case. Now, the state's opposition underscores a commitment to balancing the defendant's due process rights with the victim's rights and the need for judicial efficiency in a case that has garnered, obviously, national attention. So, bottom line is, ladies and gentlemen, the judge has the discretion. If he wants to grant a continuance, he can. I think he'd be hard-pressed to do so. If he wants to deny it, he is totally safe in doing so. The defense has had more than sufficient time to do what they need to do. And at the end of that motion, the state actually lists the ABA standards and shows exactly that the defense has complied with those ABA standards, which are not a requirement in the state of Idaho, but it's a reference point as it relates to effective assistance to counsel. We talked about this last night, and if you want to read, I read the entire motion verbatim yesterday. This is my summary of it today. But the essence of the motion is basically, we need more time, Judge, and well, we really can't tell you why, at least not to the public anyway. I know there's allegations of this third party culprit, but there's nothing been produced, so we can't rely upon that. Now, we'll see. We brought you the story the other day. Something big's happening. There's a stay to the appeal. So we'll have to wait and see what that is about, because obviously we don't have access to it. But staying in order usually means that there is going to be an appeal of some type, and we'll see what that is. We'll be monitoring those files and court records as they become available. But I am of the position of the prosecutors in this particular case. This case needs to be tried. 2.5 years is more than sufficient time to prepare, given the experienced attorneys and the team that they have assembled to get this job done. All right. Next on the docket, Lori Vallow. She continues her losing streak. After deliberating for less than an hour on Thursday, a 12-person jury found Lori Vallow guilty of conspiring to murder Brandon Boudreaux. He is the first direct victim in 3 trials that she's faced for conspiracy to commit murder, who survived and could, testify about the experience. Testimony in Vallow's 3rd trial, where she is representing herself yet again, was completed on Wednesday. Jurors returned for deliberation deliberations on Thursday. In her closing argument, Vallow said that there was no evidence of a conspiracy, but the prosecutor said that the only explanation that makes sense is that shots were fired at Boudreaux's car outside of his home by someone in the back of a Jeep. The prosecutors noted that Vallow helped her brother, Alex Cox, take the back seat and the back wheel off the Jeep. She had been seen on video putting those items in a storage unit, and Mr. Cox was not seen in the video at that storage unit. Prosecutors say he left his phone with Vallow in Idaho as an alibi while he drove to Arizona in the Jeep and tried to kill Boudreaux. This is Vallow's third criminal trial. She was convicted of murdering two of her children, 16-year-old Tylee Ryan and 7-year-old Joshua J.J. Vallow, in Idaho 2 years ago, along with conspiring to murder them and her new husband's then wife, Tammy Daybell. Earlier this year, she was convicted of conspiring to murder her then husband, Charles Vallow, in Arizona. This week, trial included some outbursts as Vallow repeatedly brought up topics that she was asked to avoid, and the judge threatened that if she continued, he might allow the prosecutors to bring in information about her 4 other murder convictions. In the first trial, in Idaho, she was sentenced to 5 terms of life in prison without the possibility of parole. She chose to wait to be sentenced for conspiring to kill Charles Vallow at the same time as the sentencing in this case. Sentencing is set for July 25th. Vallow asked it to be set as soon as possible, saying that she does not want to delay being sent back to prison in Idaho. Bryan Kohberger. That's right. Students speak out in the docuseries ahead of the Bryan Kohberger trial. So, for those who don't know, on November 13th, 2022, 4 University of Idaho students, Kayla Gonzalez, Madison Bogan, Xana Kernodle, and Ethan Chapin, were fatally stabbed at their off-campus residence at 1122 King Road there in Moscow, Idaho. Now, the gruesome discovery was made by friends Emily Allant and Hunter Johnson, who were called to the scene by surviving roommates Bethany Funk and Dylan Mortensen. Now, nearly 3 years later, Allant and Johnson are sharing their account for the first time in a Prime Video 4-part docuseries that is titled One Night in Idaho. Now, obviously, the morning of the discovery, according to court documents, details Mortensen's encountering a masked intruder in the early morning hours on November 13th of 2022 around 4 a.m. She describes seeing a man wearing all black, a mask moving towards the back side of the house, and after hearing disturbing noises and falling and failing to reach her roommates, Mortensen exchanged frantic texts and calls with Funk, the only roommate who responded. Now, messages included Mortensen's concern about an intruder and her growing panic, with one text stating, quote, "I'm freaking out right now," end quote, and describing the intruder's mask. The 2 roommates eventually retreated to Funk's first floor room, remaining there until morning. By 11:50 a.m. with no response, Gonzalez, Mogan, Kernodle, and Chapin, Mortensen contacted Allant, asking her to check out the house. Allant arrived with her boyfriend Johnson and met Mortensen and Funk on the ground floor. As the group ascended to the second floor, Johnson retrieved a kitchen knife from the kitchen for protection. There, they discovered Kernodle's body, prompting an immediate call to 911 from Funk's phone. In the call, Allant reported to the dispatcher that they had seen an unknown man in the house the previous night. Arriving officers confirmed all 4 victims were deceased. Now, the One Night in Idaho trailer highlights Allant and Johnson's emotional recounting of the discovery and their suspicion that the victims may have been stalked for months prior to the murders. Now, Allant questions why the killer targeted their close-knit group of friends, stating, quote, "There's a big realization that we had been stalked for so many months and had no clue," end quote. The series also explores the intense online scrutiny faced by survivors and friends, including Allant and Johnson, who endured accusations and death threats. Johnson notes, "People were thinking we were murderers," while other friends described being falsely implicated online, with photos of his home circulating online. Now, the docuseries features interviews with victims, family members, and friends, including Ethan Chapin's triplet siblings, Hunter and Maisie Chapin, who also attended the University of Idaho. Hunter Chapin reflects on the fear that gripped the community while the killer remained at large, saying there's this person out there who has just murdered our brother and he's still out there somewhere. Additional interviewed includes Chapin's parents, Stacy and Jim, and Mogan's parents, Karen and Scott Laramie. Now, on December 30th of 2022, police arrested Bryan Kohberger, the PhD criminology student there at Washington State University, at his parents' home in Albright, Pennsylvania. Now, Kohberger was linked to the crime through DNA evidence found on a K-bar knife sheath near Mogan's body. Cell phone records indicate the presence near the crime scene multiple times before the murders, and surveillance footage of a vehicle matching his car fleeing the area. Now, Kohberger's trial is scheduled to begin on August 11th of 2025 there in Ada County, Idaho, with the jury selection expected to begin late July or early August. Now, if convicted, he could face the death penalty. However, a June 18th hearing is set, which could alter that timeline. Kohberger's defense team has requested a postponement, citing a recent Dateline episode that aired back in May that revealed new details, including Kohberger's alleged phone records, online searches, and previously unseen surveillance footage. The defense argues that this media coverage and the need for further investigation in regards to Kohberger's background for a potential penalty phase warrants this delay. Now, the prosecutors have opposed the request, asserting that the defense has had ample time to prepare since Kohberger's arrest back in December of 2022, and the prosecution has criticized the defense for pursuing every little rabbit hole and urged the court to proceed, stating it is time to try this case. Now, Judge Hippler will consider the delay arguments and the separate closed-door discussion on whether the defense can present an alternate suspect to the jurors. The outcome of these hearings will determine whether the trial proceeds as planned. Now, obviously, these murders have sent shockwaves through Moscow, Idaho, a small college town unaccustomed to such violence, and the home there at 1122 King Road became a symbol of the tragedy, and the prolonged absence of an arrest fueled fear and speculation. Now, the One Night in Idaho docuseries aims to provide a comprehensive look at the case from the harrowing discovery to the ongoing legal proceedings, while giving a voice to those most affected by the loss of everybody, the Gonzalez, Mogan, Kernodle, and Chapin family. We'll see if this is going to be another argument for the defense to try to ask for the continuance. It's also interesting that the family members are speaking out since they were subject to the gag order. So see how that's going to play in there. I guess, what is the judge going to do? Hold the family in contempt? Going to send them to jail? I doubt it. They can't even find who leaked the material to the press for the Dateline series, so I can't imagine they're going to do anything as it relates to the family as well. Obviously, the prosecutors, I'm sure, did not want anyone to be speaking to the press because guess what? The defense can try to get those recordings just like they did in the Karen Reed case, and it's can be a prior consistent or inconsistent statement, which could come back to bite potentially the prosecution's witness in their butt.